These 4 simple tips are going to change your life. They are things that everybody can do and everybody should do. Take it from a barrister who is dealing with cases day in and day out that suffer because of these 4 simple things that you can implement in your life right now. So let's get started. The number 1 tip, which sort of underpins absolutely everything that I'm going to say and everything that you should do, is to document everything. If you get everything in writing and you get documentary evidence to support everything you want to say, then if ever you end up in court, you're going to have documentary evidence to prove what you want the court to believe. It's one thing for you to go to court and for you to say what happened and to tell the court what happened, and even when you're cross-examined as to the detail and the consistency of your evidence. If you have documentary evidence to prove everything that you want to say and everything you want the court to believe, then it's going to be far easier to persuade a court that your side of the story is true. So how do you go about documenting everything as I say? Well, first of all, the word document is a little bit misleading. I'm not just referring to documents on a piece of paper of some kind. I'm referring to keeping a record of the evidence that you intend to rely on. One such example would be a record of telephone calls. It would be one thing to make a note of the time and the date and the duration of a telephone call and with whom you were speaking, and a brief outline of the contents of that call. It would be another to actually record that telephone call as an audio recording that you can refer to later so that you can be sure of what was said during the conversation. Many people may be unduly worried about doing this, but if the audio recording is for your own personal records, then it's a household activity, it doesn't engage the Data Protection Act, and you are perfectly entitled to record that call so that you have a copy for your own records of exactly what was discussed. The only time this might be a little bit different is where there is a nature of confidence about the conversation. That might even be a conversation with your lawyer, your dentist, your accountant, and various things like this. There may well be written or even implied agreements in those situations where you're not recording something, so it's always best to check. But otherwise, for example, if you are on the telephone ordering something that's very expensive and you are making very specific inquiries as to what this item should be or anything else that you want to clarify about it, and you are worried whether what you are told is going to be upheld in the future, you are perfectly entitled to record that telephone call so that you have a record of what was agreed with the salesperson at the time. Those pre-contractual discussions and agreements will more than likely be terms of the contract if you actually go ahead. If there is a misrepresentation made to you that is a statement of fact that turns out to be wrong, you may well have an argument for breach of contract if that turns out to be false, as I said. Another form of documentary evidence that may not be a document as such might well be photographs. If there's a specific event unfolding and you are worried about liability and things like that, think dash cams and these kind of things. But of course, it's not limited to dash cams. You can take photographs or videos of any other kind of event so that you can prove exactly what happened later on. One such example is where I witnessed a horrific argument between a disgruntled customer and the security officers outside a shop. Clearly it was getting very heated and I was worried that someone was going to get attacked. So quite simply, while standing back, I just filmed the entire event. Sure enough, the police turned up a few minutes later asking whether anyone saw what was going on. Clearly, a high-definition video of the entire event is probably the most useful thing the officers could have had. So if you are in that situation, I would always recommend that you photograph and video things so that you have a record of what happened. But here is where my suggestion gets a little bit interesting. This is not just limited to events and things like that. For example, if you are ordering and receiving a very expensive item and you are worried that it's going to be defective in some way or another or indeed broken on arrival, what I tend to do in those situations is photograph the box or video the box all the way around to show whether it's sealed or not, whether it's damaged or not. And if it's very expensive, I will even have someone film as I open the item, take it out of the box. So if there's any discrepancy about it whatsoever, its very first opening when it's arrived with me is all documented in a clear video to show whether there's anything wrong with the product. Likewise, if you are sending something back, I will film putting it back in the box and sealing the box and even delivering it to a courier. This might sound like overkill, but I've had situations before where it's been questioned as to whether or not something has been sent and returned back, and I've had the evidence to prove it, so that argument fell dead straight away. Likewise, if you are sending your items in for repair and you want to ensure that there's nothing else wrong with it. One such example was sending an iPad in to have the battery changed. Again, we took photographs of the front and the back and all the way around. Sure enough, when it was returned, the back was covered in scratches and was clearly not the same back that was sent in with the iPad in the first place. It's obviously been replaced with someone else's because the one that we sent in was perfectly normal. Again, quite clearly, there was evidence to show that there was something up. Likewise, if you're sending your car in for valet service, anything of this nature, if you take photographs or video all the way around your car, you will soon know if it comes back to you having been scratched, dinked or dented. Taking the documentation to another level for my second most important point is please always get agreements in writing. The amount of times that I have clients that have spent hundreds of thousands of pounds on building work and didn't get a full written contract as to everything that was going to be done, the timescales it was going to be done by, and anything else that was agreed between the parties. If these things aren't written down, it's not that they can't be proven, but it will be much more difficult to get them proved. You have to go back and dig up countless messages, exchanges, records of conversations and payments, and so on and so forth. Much easier if you have a written contract that details everything that both parties have agreed to. Speaking of things that you've agreed to or not agreed to, you can always add things into a contract and you can always take things out of a contract. For example, I have had clients that have been upset that a certain company has used photographs of their child in a publication when they didn't agree to it in the contract. Whereas in the contract itself, it did provide that photographs will be taken and used in publications. My advice in those situations would be simply to cross out that paragraph in its entirety. If the company signs it afterwards without reading or taking note of the fact that you've taken that paragraph out, quite frankly, that's their problem. If they've signed the contract, they've agreed to it without that paragraph being incorporated. Likewise, if you add something into a contract and you alert them to the fact that you've made an alteration to it, sometimes they will tell you that it doesn't matter that you've written it in and they'll sign it and say that it's not enforceable. But that's actually not true at all. If it's part of the contract when both parties sign it, then both parties have agreed to it. And subject to it being unfair to one party or another, which would render it unenforceable in most cases, then it's going to be part of the contract and it's going to be something that you can enforce. But when you've got to a stage where everything is in or taken out that you want in this written agreement that I really hope that you all do after watching this video, clarify things that are in that contract, because if you don't know what it means, then you don't really want to be agreeing to it. But if in the event that you clarify what it means and it looks like it could be a little bit ambiguous, then document the fact that you've clarified what it means, and so that you have an understanding of what that term means. So if later on your understanding is wrong, but they have assured you that your understanding was correct, then again it might render that term unenforceable because they've assured you of a different meaning, which was what you agreed to. A court is always going to look to what the parties agreed in the contract and whether there's any scope for clarifying what that agreement was. The court is going to be slow to imply any meaning to a contract if there is evidence that there was an agreement to the contrary. The third major yet simple piece of advice that I can give all of you watching, and I hope you take me up on after this video, is always check out the history of the company from which you are buying something, particularly if it's very expensive. It's one thing buying from somewhere like Amazon directly, where you know you can reasonably rely on Amazon for your purchases, but if it's a third-party seller through Amazon, or it's a completely independent website and company that you've never heard of, then you absolutely must undertake some very basic due diligence on the company to see what you can find. These days, while the review sites are not perfect, there are enough of them to get a feel for whether other people have dealt with this company before. If no one has dealt with the company before and there are simply no reviews, then it suggests it's a brand new company, in which case I would check the records at Companies House to see when the company was incorporated. If it was incorporated 3 weeks ago and you're looking to spend £15,000-20,000 with this company, then I would want much more assurance than just what it says on their website. And the fourth tip that I would give all of you watching overlaps a little bit with each of the others, but particularly my tip number 2, which was get your agreements in writing. Tip number 4 is always read the contracts and always read the rules that you get involved with. I know some contracts might seem overly long and laborious to read. Most of it is actually boilerplate, such as entire agreement clauses, which means everything you've agreed is contained within that one contract. Lots of them will have force majeure clauses, all of which make these contracts overly long. But there's usually some specific bit within the contract that you will want to check out. Again, using an example that I used before with regards to photographs and social media. If you do not want photographs or films published of your children for marketing purposes, then please do check the contract to see whether there is some kind of provision that allows them to do it. You are also checking the contract for what else you are agreeing to, because the law is not going to protect you from a bad bargain just because it wasn't good value. The law will protect you if it is a completely unfair term or completely uncertain term, or it's in breach of some consumer rights. But for example, if it is just an overpriced item but you've agreed to pay for it, then the law won't protect you, generally speaking, from a bad bargain. The same can be said with a set of rules, whether that is a set of rules for an event that you're participating in or simply a place that you are going to that has its own set of rules. You need to be familiar with what those rules are. Many contracts, events, and other situations will require you to comply with a set of rules, but if you don't know what those rules are, then you can't comply with those rules, and there may well be penalties for those rules. The same can be said for something as simple as parking your car on a privately managed car park. There will be a set of rules with which you must comply, and so long as they are sufficiently clear and visible from where you are parked and around the car park, you will be held to those rules as terms of the contract. And speaking of parking, if ever you've received a parking charge notice or you're worried about them, you might want to check out this video here.